Thank you, Chairman. I will be as brief as I possibly can. First of all, to say, of course, it is my pleasure to share some thoughts and insights with you today on the very pertinent topic of environmental dispute and, of course, its resolution. And more particularly on the initiatives that the Permanent Court of Arbitration has taken in this very regard. As many of you are well aware, the PCA is an intergovernmental organization headquartered in the Peace Palace in The Hague. Its mandate is to provide a permanent framework within which arbitral tribunals constituted to resolve specific disputes can operate. Since its founding over a century ago, the PCA has grown into a modern, multifaceted arbitral institution situated at the juncture between public and private international law. And today, the PCA provides services for the resolution of disputes involving various combinations of states, state entities, intergovernmental and non-governmental organizations, as well as private parties. The PCA is currently experiencing the most activity in its history since its creation in 1899. The charge placed on the PCA by the international community is to aid the resolution of disputes of international concern. Disputes relating to the environment, which can include a broad spectrum of disputes implicating environmental preservation and sustainability, remedies for environmental damage, or rights related to natural resources certainly fall within that charge. The PCA has indeed given much attention to the development of the rapidly growing and increasingly important area of international environmental law and dispute resolution. Perhaps the PCA's greatest contribution to date is its development of mechanisms that facilitate the efficient and peaceful resolution of environmental disputes when they arise. The PCA was motivated to contribute to the international legal order as it concerns environmental disputes. As you well know, there are hundreds of international treaties aimed at resolving the growing number of issues related to environmental protection and natural resource usage, a number of which are multilateral. Not only as a result of multilateral treaties, but also, I believe, by subsequent agreement of the parties, the PCA has frequently been called upon to administer international arbitrations that involve environmental or natural resource issues. For instance, the PCA has administered 4 such arbitrations under the dispute resolutions provisions of UNCLOS, 1 arbitration under the OSPAR Convention, or 1 under the Rhine Chlorides Convention, and indeed several cases under the North American Free Trade Agreement. Each of these conventions provide for arbitration as a dispute resolution mechanism. The PCA has also administered several arbitrations under bilateral treaties and private contracts that involve environmental and natural resource components. Indeed, arbitration alongside adjudication has become one of the favored means of environmental dispute resolution consistent with Principle 26 of the Rio Declaration and Article 33 of the UN Charter. A well-known example of an arbitration involving environmental issues administered by the PCA is the MOX plant arbitration case between Ireland and the United Kingdom. This case, initiated under Annex 7 of UNCLOS, concerned a nuclear waste plant and the alleged pollution of the local marine environment. This case began in October 2001 when Ireland instigated proceedings under UNCLOS against the United Kingdom, requesting that the tribunal find, amongst other things, that the United Kingdom had failed to take measures to correctly assess, prevent, reduce, and control pollution of the Irish Sea marine environment from discharges of radioactive materials. The PCA acted as registry in this arbitration from the constitution of the tribunal through Ireland's request for provisional measures and 6 procedural orders until the tribunal put on record Ireland's withdrawal from its claim following the declaration by the European Court of Justice in May 2006 that it had competence over the dispute. The PCA has also acted as registry in the related OSPA arbitration, which concerned the dispute between Ireland and the United Kingdom again over access to information that had been redacted from reports published as part of the approval process for the commissioning of the MOX plant. The point to be made here is that the arbitral tribunals in these disputes had to draft their own rules of procedure. Yet, as our experience has shown, negotiating procedures under each and every new instrument can be costly and a time-consuming affair. And that is what the PCA recognized and identified that there was a need for dispute resolution procedures tailored especially for disputes involving environmental and natural resources issue. And allow me to avail myself of this opportunity, Mr. President, to recognize most cordially and gratefully Dr. Alfred Rest, who has been, in a way, the auctor intellectualis of this very forward-looking and far-reaching initiative. Consequently, the PCA set out drafting a set of procedural rules especially designed for arbitrations relating to the use of natural resources and the environment. The PCA environmental rules were drafted by a special working group chaired by Professor Philip Sands, and it took roughly 2 years for the member states to finally agree, matters relating to sovereignty being at the heart of the debate, as you would expect. The rules were eventually released in 2001, and shortly thereafter the PCA released a similar set of procedural rules for conciliation procedures. Thus, the PCA environmental rules addressed a lacuna that existed in environmental dispute resolution, especially in matters relating to the appointment of experts, confidentiality, interim measures, speed of arbitral proceedings, and the enforceability of the final decision. The rules strengthening confidentiality guarantees, thus allowing parties to comply with their national laws and manage any sensitive information or even political constraints. As time is often of the essence in environmental disputes because of the possibility of irreversible damage to the ecosystem, the environmental rules also have tailored provisions for swift appointment procedures where a party has failed to appoint and the ordering of provisional measures. Tribunals acting under the rules apply the national and/or international law and rules of law it determines to be appropriate, given that in international environmental law, issues often arise in a national context and become transnational at a later stage. Parties adopting the PCA environmental rules may draft from a list of experts in international environmental law and arbitration maintained by the PCA in order to assist them in constituting a tribunal with the requisite expertise in the subject matter of the dispute, something which is often indispensable for the proper resolution of the more technical aspects of an environmental case. The PCA also maintains a list of experts in environmental science, and the environmental rules allow a tribunal to appoint one or more of these experts directly for assistance in resolving more nuanced scientific issues, such as assessing the magnitude of an environmental risk and identifying the cause of environmental damage. These expert lists may be found on the PCA's website. The environmental rules were thus designed to provide an efficient procedural framework for the resolution of environmental disputes that would be, so to speak, prêt-à-porter and could be incorporated by reference into treaties and contracts. Presently, there are 2 arbitrations being administered by the PCA under its own environmental rules. Both of these arbitrations concern carbon emissions in the context of the Kyoto Protocol. The first dispute concerns an alleged breach of an agreement for certified emission reductions in the context of carbon emission trading under the Kyoto Protocol, and this arbitration illustrates the growth of the carbon market as a mechanism established by states to meet their international environmental obligations and involving private actors in their implementation. An increase in the number of disputes in this area may reasonably be expected. The second dispute involves the alleged expropriation of an investment in the area of reduction of carbon emissions during the distribution of natural resources. The underlying contract concerns carbon credits sold to carbon-emitting entities to offset their emissions in excess of the Kyoto Protocol quotas. The claimant in this dispute alleges breach of the agreement by the respondent, a state in this case, and claims compensation through carbon credits as opposed to monetary damages. The PCA has monitored the number of references to the PCA environmental rules in Kyoto Protocol emissions trading contracts and has noted a dramatic increase. Numerous public and private entities are referring to the PCA environmental rules as the arbitration procedure of choice in the emissions trading and related contracts. Indeed, the International Emissions Trading Association recommends the PCA environmental rules in its various model emissions reduction purchase agreements. The PCA's list of experts also include emissions trading experts that can be relied upon for the constitution of an arbitral tribunal or to serve as tribunal-appointed experts. The PCA is currently investigating the possible need for the establishment of a further set of optional rules to meet dispute resolution requirements that the international community might have in the future. To sum up, Chairman, today we live in an era of globalization and industrialization that directly affects our environment. As the recent Copenhagen Climate Change Conference showed, progress towards international agreement on major environmental issues is still I would say, dramatically slow. In an area of continued diversions, it is of the essence that parties to environmental disputes are able to make use of internationally endorsed, specialized dispute resolution mechanisms that provide a solid and reliable procedural framework to their proceedings. It is within such a uniform context, endorsed by the international community, that crucial jurisprudence over environmental issues so decisive to the strengthening of the international legal order may best develop. It may thus promote environmental governance and access to justice. Thank you.